you're our second speaker this morning, Katarzyna Sękowska-Kozlowska. I hope I haven't done too much violence to your beautiful name, but it's my pleasure to invite you to talk on the topic of domestic violence and discrimination. I remind everybody that Katarzyna is an assistant professor and director of the Poznan Human Rights Institute. So without more ado, you have the floor, Katarzyna.
Thank you very much. So first of all, I will share my screen. Can you see my presentation?
We can.
Great. Sorry. I tried to hidden. Okay, now it's better, I think. Okay, so I can start. Can you see and can you, I hope you can hear me and everything is fine. So first of all, thank you very much for inviting me, Michael, and thank you very much, Marie, for invitation, and let me congratulate you this project, which seems to be really excellent, and I'm looking forward to see your the fruits of your project. So I'm very happy to speak after Christine, who did excellent presentation about racial discrimination, and now we will move to gender discrimination, and I want to talk a little bit about domestic violence and proving gender discrimination in domestic violence cases. The brief plan of my presentation. I will speak a little bit about Opuz versus Turkey, which the case obviously you know very well, which established some kind of standard of proving discrimination in domestic violence cases. Then I will focus on the subsequent practice of the court in domestic violence cases, and some concerns or problems or point for discussions that I see when analyzing this practice. And then after the case, which I think is a real breakthrough in proving gender discrimination in domestic violence cases, so Volodina versus Russia. So first of all, here's the list of cases that I examined. And of course, these are cases, we don't have inadmissible cases here. So I based this analysis mostly on the fact sheet on domestic, of the court's fact sheet on domestic violence, and also on my own research. So these are cases which I examined for this presentation. So as for Opuz versus Turkey, you know very well that this is the case that introduced the standard of finding that violence against women may be recognized as a form of discrimination, of a gender discrimination. And this was the first case when the court referred to international standard on gender discrimination and domestic violence, mostly CEDAW Convention and Belém do Pará Convention, and found that also in recognizing cases before court, the facts that happen in domestic violence case may reveal gender discrimination. So this is this point A that I refer to, and here we have the scheme of considerations that the court applied in Opuz versus Turkey. Unfortunately, in the further cases, we don't have this such a clear scheme that was presented here by the court. So first, I want back again to this meaning of discrimination, the context of domestic violence, and this refer to international standards because this is very well established and this is repeated by the court in other cases. Another issue that the court examined was the approach to domestic violence in Turkey, and this I call general approach, and I will look on another cases how this general approach of proving systemic discrimination discrimination was found by the court. And another point that the court made was whether the applicants in this case were discriminated by the state authorities. So I call it individual approach. So if the victim itself or herself was discriminated against because of her gender or sex. So now I want to go to subsequent practice of the court, and first there is the issue of admissibility and producing prima facie evidence. So as Christine already said, this is a really challenging issue, of course, in proving discrimination. But what I see from the examination of the cases of domestic violence, usually showing information about systemic violence, and I will back to this evidence, usually it's enough to establish prima facie evidence for the court and to shift the burden of proof. So of course, the statistics and information about domestic violence in a given country. However, we can see, for instance, from the case, mostly from the case A versus Croatia, that numbers are not enough. So this is not enough just to present information, but also to show how they work for discriminating, how they work for creating this discriminatory environment in a given country. So it should be followed, it should be combined with an analysis and with a clear assessment, and trying to show that numbers related to domestic violence counts for discrimination. So if already the prima facie evidence is established, now I would like to talk about a little bit more about this, what I called general approach and individual approach. So as you know, in a case Opuz versus Turkey, the court found that there was a gender discrimination, discrimination based on sex, because the applicant was able to show, supported by statistical information, that domestic violence affects mainly women, and that there was general and discriminatory judicial passivity in Turkey. So now I want to have a look on further cases, but of course not talking about them in detail. But the question is, so what information should be presented by the applicant to show that that there is systemic discrimination in a given country? So first of all, this undisputed or unchallenged information by the government. So of course this is related to the shift of proof. And another issue, very important, is statistics speak louder. This is the phrase that I borrow from the judge Pinto de Albuquerque and his separate opinion in case Volodina. So in cases of domestic violence, the statistics are extremely important source of information, and I will back to this statistics a little bit later. So what numbers? And here, first of all, mostly numbers and sex of the victims of domestic violence in a given country. For instance, numbers about length of proceedings in domestic violence cases, or about numbers of shelters, if there was a case about the victim who was not supported enough in her situation. So this is about numbers. Another thing is, and is about practices reported by the NGOs. So not only numbers, but also the court referred, for instance, to a systemic practice that were shown in NGO reports about, for instance, adjudicating domestic violence at the country level, or how the victims of domestic violence were treated by the police. So these are this kind of analysis. And of course, as I already said, it has to be supported by relevant analysis. So not just facts, but also it should be demonstrated how it works for a given case. And also one important issue, I took it also from Judge Pinto de Albuquerque, lack of official data is also an information. As we know, in quite a lot of countries, there are really serious shortcomings in terms of gathering official data and gender disaggregated data. So if the country is reluctant to gather this kind of information, this is also an information that can work for the case and work for the victim. So what about sources, and what are the sources of information that are presented to support the proof of systemic violation? Of course, first of all, official statistics and documents for, so for instance, there were cases of where victim referred to official statistics of the ministries or the statistics bodies in a given country, or some specific documents. Also, what I think is very important, the academic research. Also, we had the cases where the academic research was called as an evidence, and the court took it into consideration. And another another very important source, reports by international and local NGOs. And this is quite interesting because in Opuz case, the court also referred to this source, and it underlined that these were information provided by a very well recognized and credible NGOs. It was in that case Amnesty International or Human Rights Watch and some other big Turkish NGO. But also we can see even in Opuz and in other cases that also reports and information prepared by smaller or local NGOs are also taken into consideration. And another very important source of information, these are findings of international bodies, and two leading sources. These are concluding observation of the CEDAW committee on a given country, and reports from country visits of UN Special Rapporteur on Violence Against Women. And for sure, the information prepared by Grevios, or the group that monitors the Istanbul Convention, are or will be also this kind of source that can be very supportive in that kind of cases. So now I move into what I called individual approach. So proving that authorities' action amounted to the violence in a given case, that the state's behavior was marked by discriminatory attitude toward the applicant as a woman. And I think that it seems clearly from the case law that in some cases this is much more difficult to prove for the victim. So this is this evidence of regularly turning a blind eye to the repeated acts of violence. So this is from Halima Kilic case. So most of all, it's enough to prove the passivity of the state authorities in a given case. But of course, it depends on circumstances. And here are some selected examples from various cases of facts or of states' behaviors of the public authorities that amounted for gender discrimination. So notorious failures to undertake actions, downplaying incidents of domestic violence, victim blaming, suggesting reconciliation with perpetrator or being nice, shielding perpetrator from responsibility, or not enforcing protection orders, or not initiating ex officio proceedings if it was possible in a given case. So these are just some examples of the circumstances that worked for the victim in proving that she was discriminated against. So now I go to some concerns or some problems that I identified when researching these cases. So first of all, what is the balance between individual and the general approach in the court's attitude? So what I mean is that in some cases we see that mostly although the court said that there was a gender discrimination with regards to how the victim was treated, we can clearly see, even from Opuz case, that the court focused mainly on systemic discrimination and on the statistics and numbers than on a particular situation of women, of a given victim. And also we have some cases when this assessment was very balanced. Or we have cases that the court focused more on individual situation, on the victim, and more about things that happened in her situation. Another thing is what is the threshold for establishing systemic gender discrimination? And this is this hesitation and this problem which we can see in Talpi's case and in dissenting opinions of Judges Spano and Eike, that for them, now I quote Judge Spano, societal discrimination and high level of domestic violence are not in and of themselves enough ground for finding violation of Article 14. So if it's not enough, the question is how bad domestic violence and the state's behavior in a given country should be to allow to establish systemic gender discrimination. And another problem is to what extent the court is bound by its previous findings with regard to existence or not existence of systemic discrimination in a given country. And this we can see also from these Italian cases, because in a rumor case, there was no, the discrimination was not found. Then from Judges Spano and Eike, this was the argument to say there was no discrimination in Talpi's case either, because it happened in the similar time, and the state's behavior, the general attitude of the state should be considered as the same. But the point was that in the rumor case, there was a clear problem with the clear shortcoming as for the victim to proving the systemic discrimination. It was done in a much weaker way than it's happened in Talpi's case. So why should the victim in one case be punished for inability of the victim in another case to prove systemic discrimination? And on reverse, in the Turkish cases, we can clearly see that findings in Opuz case works for other cases that happen in similar time or after on, but that country did not introduce significant reforms.
Katarzyna, I'm sorry to interrupt, but You've got 2 minutes.
Yeah, thank
So-
you. Yeah,
So
yeah.
you've got this
Yeah,
other important case to look at.
Yeah, so now I go quickly to Volodina, which I think it's a consolidation and clarification of the 10 years standards. First, as for a shift of burden of proof, the court says clearly that if it has been established that it affects women disproportionately, the violence, the proof shifts onto the government. So, well, it's summarizing what was already said in previous case law. So then the court goes to prima facie evidence. And what I think it's important is to show that the court said that there are no procedural barriers to the admissibility of evidence or predetermined formula for its assessment. Well, this is quite clear from the court's practice, but I think it's showing the openness of the court for various sorts of proofs and of sources of information. And here is again, this is referral to international standards and to the sources that I've already mentioned. And as for individual situation of the victim, it has to be demonstrated that the action go beyond a simple failure or delay in dealing with the violence. But what is the most important is that the court says that once a large-scale structural bias has been shown to exist, the applicant does not need to prove that she was also a victim of individual prejudice. So if systemic violence, systemic discrimination was proved, if there was enough data, a clear demonstrating systemic discrimination, there is no need for victim to demonstrate that discrimination happened in her case. But if there is insufficient evidence of a systemic discrimination, then she has to be able to prove that her case was not properly dealt by the state authorities. So to conclude, what I wanted to show you is this evolution of establishing evidence rules in domestic violence cases. And what I think is very important in this kind of cases is our gender-sensitive evidence-based research on domestic violence in member states. And here, for sure, also obligation imposed by Istanbul Convention works for the producing this kind of materials. And as for breakthrough in Volodina case, this is some kind of evidence facilitation for applicants, but it's too early to see how it is and will be applied by the European Court of Human Rights Practice, and if we have some new stable rule in its adjudication. Thank you very much for your attention.
Thank you indeed for this very interesting presentation.